As the camera pans back into the familiar courtroom, a quiet tension settles over the room. The door creaks open, and in walks Miss Tyler, her arms weighed down by thick, overstuffed binders. Her footsteps are steady, but the weight she carries isn't just physical, it's emotional. Today, she's not here to argue or plead. She's here to prove. She approaches the bench with a purpose, respectfully handing over the documents she believes will change everything. The judge raises an eyebrow, intrigued, and carefully begins to flip through the binders. Miss Tyler calmly explains, her voice tinged with both exhaustion and determination, that the binders are filled with receipts, invoices, and insurance records. She's been paying for her children's medical coverage out of her own pocket, she says, month after month, even while being held to a strict child support obligation. Each page is a quiet declaration. Co-pays for doctor visits, dental bills, vision exams, prescription costs, line after line, totaling thousands of dollars. She points to statements showing automatic payments, enrollment confirmations, and even out-of-network emergency bills she covered. The courtroom remains silent as the judge continues reviewing. For the first time in this long, winding case, Ms. Tyler seems to have taken control of the narrative. She's no longer reacting. She's presenting. Her body language reflects a quiet confidence, and there's a noticeable shift in energy. The judge pauses, looks over his glasses, and addresses her directly. So you're saying these payments were made consistently, without the court ordering you to do so? Ms. Tyler nods. Yes, Your Honor. I've always done what I believed was right for my kids. I just couldn't let them go without coverage, no matter what else was going on. There's a moment of respectful silence, even from the opposing side. This isn't just paperwork. It's proof of her involvement, her care, and perhaps her misunderstood contributions all along. The judge sets the binder down and leans back, clearly impacted. Whether this will absolve her from further payments remains to be seen. But one thing is now undeniable. Miss Tyler came prepared, and this time she brought the receipts literally. The courtroom atmosphere tightens again as Miss Tyler remains standing, her expression shifting from composed to visibly shaken. She hesitates for just a breath, then reaches into her folder for a single, thin sheet of paper. Not a stack this time, but something far more pointed. Her voice takes on a new tone, not defensive now, but wounded. She turns slightly toward the judge, then glances at Mr. Lewis as she speaks. Your Honor, I need to bring something serious to your attention, she begins, her voice quivering with restrained emotion. One of my children was burned. He was home alone at the time, and Mr. Lewis was supposed to be watching him. A murmur rolls through the courtroom gallery. The judge stiffens his chair, motioning for clarity. Ms. Tyler presses forward, placing the document on the bench. It's a hospital bill, clearly marked with emergency treatment codes, and the child's name printed at the top. She explains that her son suffered a significant burn injury while in Mr. Lewis's custody, an incident that, according to her, never should have happened. She recounts a phone call, how she learned her son had been left unattended, and how he'd accidentally injured himself trying to heat up food in the kitchen. She describes the panic, the hospital visit, and the fear etched on her child's face as they treated the burn. And then, just as quietly, she adds that she paid the bill herself, once again stepping in when no one else would. The judge reads over the document carefully, then raises his eyes toward Mr. Lewis. There's a long pause. No one speaks. Even the courtroom staff seem to stop moving. Mr. Lewis shifts uncomfortably in his seat, but says nothing. The silence grows heavier with implication. Ms. Tyler's voice breaks through again. This isn't just about money. It's about safety, about responsibility. I need to know my children are being cared for when they're not with me. It's not just an accusation. It's a plea, a mother saying, in no uncertain terms, that her trust was broken and that her children may have suffered because of it. Her hands tremble slightly as she returns to her seat, and the entire room feels the gravity of what's just been said. In that moment, the case shifts. It's no longer just a dispute over child support or insurance payments. Now, it's about protection, accountability, and the unspoken wounds that no binder of documents can fully explain. As the tension in the courtroom simmers, Ms. Tyler rises once more, this time carrying a stack of paper in her arms. Not legal documents, not insurance paperwork, but what she calls the proof. With steady hands, she approaches the bench and presents them to the judge, a collection of printed Cash App screenshots, digital bank transfers, and statement excerpts that she insists confirm she's been paying support regularly. I've been sending money every month, she says, her voice firm but clearly weary. It may not have always been the exact amount ordered, but I've never abandoned my kids financially. She walks the court to the timeline of her payments, highlighting specific dates, amounts, and recipients. Each screenshot shows what looks like a transaction to Mr. Lewis. Some are labeled with brief notes like kids or school, while others are blank, containing no memo at all. The judge leans forward, squinting at the pages. These amounts, they vary, and many of these entries have no indication of what they were for, he observes. Why weren't they consistently labeled for support? Miss Tyler sighs. Honestly, Your Honor, I wasn't thinking about memos. I just sent money whenever I had it. Rent was due, school supplies came up, medical bills. I just did what I could. I didn't realize every dollar needed a label to count. Her tone is emotional but restrained. She isn't trying to avoid responsibility. She's trying to show the reality of juggling bills, children, and a fractured co-parenting arrangement. To her, the transactions were self-explanatory. To the court, they're murky at best. Mr. Lewis, arms folded, remains quiet for a moment before finally interjecting. She sent money, sure, but I never knew what for. Sometimes it was $40. Sometimes it was $100. It's not consistent. And when I asked, she'd just say, for the kids? That doesn't cover support the way the court ordered. The judge acknowledges both sides, but stresses the importance of transparency when it comes to child support payments. Without proper documentation or memos, he explains, the court cannot conclusively determine what those payments were intended for. Were they gifts? Reimbursements? Partial support? The ambiguity places Ms. Tyler at a disadvantage. The judge doesn't dismiss her efforts. He even nods at her initiative in bringing financial records. But he's also clear. The court requires clarity, not just intent. Ms. Tyler's informal approach to fulfilling her obligations may have satisfied her conscience, but legally, it falls into a gray area, one that could end up costing her more in the long run. As she returns to her seat, Ms. Tyler looks frustrated but not defeated. She mouths something under her breath, perhaps a comment to herself about how hard she's tried. The reality of co-parenting through courts and cash apps is messy, and today's hearing is a painful reminder that effort doesn't always translate to legal compliance. As the courtroom settles from the previous exchange, Ms. Tyler rises again, her voice taking on a sharper edge, not angry, but undeniably disturbed. She raises her hand slightly, requesting to speak further, and the judge nods. What comes next is not about money, insurance, or receipts. It's about where her children are laying their heads at night. Your Honor, she begins, I have serious concerns about where my kids are living. She pauses, visibly emotional, then continues. They're sleeping on the floor, not in a bedroom, not even on a couch. On the floor, in a small house, where they share space with dog cages. In the same room. They were evicted from their apartment, and now live with Mr. Lewis's mother, and it's not a healthy place. The courtroom stiffens. Mr. Lewis, who had remained composed, now shifts in his seat. His jaw tightens slightly, but he doesn't immediately respond. Ms. Tyler holds up a phone, offering pictures to the court. The screenshots aren't shown to the audience, but the reaction from the judge suggests he's taken aback. She claims they show sleeping bags and blankets on hardwood floors, positioned just feet away from where dogs are crated. She explains that one of the children mentioned the smell of urine in the room and the sound of barking keeping them up at night. It's not safe. It's not sanitary, she insists. And it's not how children should be living, especially when one of them has asthma. The judge leans back, taking a moment to process the information. Do you have evidence beyond the photographs? He asks. Ms. Tyler nods. My daughter told me herself, crying on the phone. She said, Mom, I don't even have a bed. All eyes turn to Mr. Lewis now. His defense is calm, but defensive. It's temporary, he explains. We're doing the best we can. My mom took us in after the eviction, and yes, we're sharing space, but the kids are clean, fed, and loved. I'm looking for another place. I just need time. But the judge makes it clear, intent and love are important. But the court also considers physical well-being and living conditions when evaluating custody and support arrangements. The conversation veers into what constitutes an acceptable standard of living. Ms. Tyler insists that she has a stable 2-bedroom apartment where the children have their own beds and space to study, eat, and sleep without being near animals or sleeping on hard floors. This is not just about pride, Your Honor, she says. It's about dignity. My kids deserve better than this. The judge doesn't offer a final ruling in that moment, but his demeanor grows more serious. He informs both parties that he will need to consider this information carefully and may call for a welfare check or request that Child Services conduct a home visit to verify the conditions. As Ms. Tyler returns to her seat, she exhales sharply, not with satisfaction, but with the heavy breath of a mother who's been holding in too much for too long. She came into court to defend herself, but now, more than ever, she's fighting for her kids' comfort, stability, and safety. The tension in the courtroom, already simmering from previous exchanges, reaches a new peak when the subject of the children's birth certificates is raised. The judge, sifting through documents submitted by both parties, furrows his brow and pauses. "There's a discrepancy here," he says slowly, holding up a set of papers. "The information on the children's birth certificates doesn't appear to match." Ms. Tyler straightens in her seat and immediately responds. "Your Honor, I have the original birth certificates right here," she says, pulling out a plastic folder and producing a pair of crisp, embossed documents. She walks them to the bailiff, who passes them up to the judge. "These are from the state's Vital Records Office," she adds confidently. "Real seals, real signatures." The judge examines them closely and nods, acknowledging their authenticity. Then he turns to Mr. Lewis. "What you submitted appears to be a photocopy, and the details don't match these." Mr. Lewis looks confused. "These are the ones I've had since they were born," he says. "They were in my files. Maybe they're older versions?" Ms. Tyler's frustration boils over. "Older versions? One says our son is a girl," she exclaims, pointing at his paperwork. "And his age is off by a whole year. How does that even happen?" Gasps and murmurs ripple through the courtroom gallery. The judge raises his hand to quiet the room. Mr. Lewis, visibly flustered now, flips through his paperwork. "I don't know," he mutters. "This is what I was given. I didn't forge anything." Ms. Tyler jumps back in. "You don't have to forge anything to confuse the court. All you have to do is keep submitting sloppy, mismatched papers. You're trying to make me look like I don't know my own kids' identities." At this point, the judge's demeanor shifts. He's no longer just a neutral observer. He becomes more stern, addressing both parties. These are serious inconsistencies, and whether intentional or not, they make it incredibly difficult to establish clear facts. He turns to Mr. Lewis again. "Can you verify where these copies came from?" "I think my mother had them," Lewis says hesitantly. "She handles a lot of our records." Ms. Tyler interjects quickly, almost incredulously. "So your mother gave you papers that misidentify your child's gender? And you didn't notice?" The courtroom falls silent again. The judge sighs deeply and leans back in his chair. "We're not going to litigate every piece of paper today," he says, "but this will absolutely impact the court's trust in documentation going forward." He makes a note in the file and tells both parties to prepare certified, official records for all future hearings. As Ms. Tyler returns to her seat, she looks over at Mr. Lewis, not with anger, but with disbelief, in a case already burdened by emotion, financial stress, and questions of responsibility. Now the very identities of their children are being muddled. And for Ms. Tyler, that seems to cross a line she didn't even know existed. Just when the courtroom appears to be catching its breath, Ms. Tyler introduces a new piece of evidence, one she believes will decisively tilt the balance in her favor. With a sense of anticipation, she stands and tells the judge, "Your Honor, I have a letter here from Mr. Lewis's brother. He outlines the truth about who's been caring for children, and it's not Mr. Lewis." The courtroom stirs. Even Mr. Lewis looks caught off guard. Ms. Tyler hands a letter to the bailiff, who delivers it to the judge's bench. "This statement confirms," she continues, "that Mr. Lewis's brother has seen firsthand that I've been the one financially and physically supporting the kids, especially during the months he claimed they were solely in his custody." The judge begins reading the letter aloud, his brow furrowed in concentration. The document includes statements about where the children were staying, who was feeding and clothing them, and references to conversations allegedly overheard. Conversations in which Mr. Lewis's brother purportedly admits that his sibling wasn't acting in the children's best interests. But before the judge can finish, Mr. Lewis quickly interjects. "Your Honor, I object," he says sharply. "That letter is fake." The courtroom murmurs again. The judge sets the paper down slowly. "Fake?" "Yes," Mr. Lewis insists. "I spoke to my brother last night. He never wrote this. He wouldn't write this. This is made up." The judge raises an eyebrow. "Do you have any proof that it's not his?" "I can call him right now," Mr. Lewis offers. "Put him on speaker. He'll tell you himself." Ms. Tyler immediately responds. "That's not necessary, Your Honor. The letter was sent to me directly from his email. I printed it exactly as it was sent. But the judge, sensing the tension escalating into a credibility war, holds up a hand. Let's stop right here. He looks directly at Ms. Tyler. Even if this letter were legitimate, it's hearsay without verification, and now that its authenticity is under serious question, it cannot be accepted into evidence. Ms. Tyler's face tightens in frustration. So he can just deny it and it's gone? Just like that. The burden is on you to prove that it's genuine. The judge replies firmly. If Mr. Lewis's brother is willing to make such statements, he can appear in court and swear to them in person. Until then, this letter carries no legal weight. He places a letter aside. Unofficial, unverified, and now dismissed. Mr. Lewis exhales, clearly relieved, while Miss Tyler shakes her head and mutters under her breath. The moment, which could have been a turning point for her, evaporates in seconds. For the judge, this episode only highlights a recurring theme in the case, a lack of concrete, verifiable evidence, and a deepening mistrust between two parents whose personal war continues to complicate every attempt at clarity. As tensions continue to build in the courtroom, the judge turns his attention once again to the letter Miss Tyler previously submitted, allegedly from Mr. Lewis's brother. At first glance, it seemed like a potential game changer, but now, under scrutiny, it's quickly unraveling. Holding the document between his fingers, the judge leans back in his chair, peering over his glasses with a critical eye. Ms. Tyler, he says calmly, I've looked through this letter several times now, and while I understand what you're trying to establish with it, I have serious concerns. The courtroom falls silent. Everyone seems to brace for what's coming next. This document, the judge continues, tapping it with his index finger, is formatted in a way that's unusual. It looks more like a typed legal brief than a personal statement. Professionally formatted, margin alignment, font consistency, header structure, spacing. That's not typically how someone writes a letter to a court, especially not a family member who's speaking from personal experience. Miss Tyler shifts in her seat. I didn't write it, Your Honor. It was emailed to me just like that. The judge doesn't appear convinced. Even if that's the case, the court has to ask, why would Mr. Lewis's brother go to the trouble of formatting it like an attorney's filing? Why not just write it plainly like most people would? He pauses before continuing, his voice growing more deliberate. More importantly, there's no signature, no contact number, no indication this came from a verifiable source. And now we've heard Mr. Lewis challenge its authenticity outright. Mr. Lewis folds his arms, nodding slightly as if to affirm the judge's assessment. The judge sets the letter down decisively. Without corroborating testimony or forensic verification of the document's origin, I cannot, in good conscience, allow this letter to be submitted as evidence. The formatting, frankly, raises more red flags and it clears up. Ms. Tyler's face hardens. So it doesn't matter what it says? The judge looks directly at her. It matters, but only if I can trust that it came from who you say it did. And right now I can't. He then speaks more broadly to court, his voice tinged with frustration. We are not here to play detective. This court deals in verifiable facts, not speculation or professionally polished claims that can't be traced back to a legitimate source. With that, the letter is officially stricken from the record. The bailiff takes it from the bench, and is placed into a separate folder, acknowledged but legally irrelevant. And in that moment, any advantage Miss Tyler hoped to gain from the letter vanishes. The courtroom atmosphere tightens once more. In a case already clouded by accusations, distrust, and conflicting accounts, the judge's dismissal of the letter adds yet another layer of doubt about the evidence and about the motives behind it. As the hearing unfolds, what was already a tense and emotionally charged courtroom takes a turn for comical, albeit unintentionally. Ms. Tyler and Mr. Lewis, clearly well acquainted with each other's buttons, begin to engage in a back and forth that veers far from legal decorum and squarely into the realm of sarcasm, pettiness, and personal jabs. It starts innocently enough, with the judge asking for the names and birthdates of the children involved. But when Ms. Tyler begins listing them off, Mr. Lewis suddenly interjects with a raised eyebrow. You forgot to mention earth, wind, and fire. The remark sparks a ripple of laughter through the gallery, some of it muffled, some of it not. The judge raises a hand to quiet the room, but it's clear the tone has shifted. Excuse me? Miss Tyler fires back, clearly annoyed. Ain't nobody in my house named after band, sir. Mr. Lewis leans back, arms crossed. I mean, with all these made-up names and birth certificates flying around, it's hard to tell. The judge sighs and gently rubs his temples. Let's please keep this professional. But the sarcasm continues to bubble just beneath the surface. Ms. Tyler throws in a jab about Mr. Lewis's living conditions. At least my kids ain't sleeping next to no dog cages like yours are. Lewis counters without missing a beat. Yeah, well, at least I don't got strangers writing fake letters to judges for me. The courtroom tension flips between comedy and hostility with every exchange. Both parties appear to forget they're under oath as their banter turns into a blend of stand-up roast and therapy session. One moment, they're bickering about birth certificates. The next, they're accusing each other of being petty and vindictive. Even the judge can't help but comment. This is not a talk show, he says firmly. We're here to resolve serious matters. I expect both of you to act accordingly. But like oil and water, Ms. Tyler and Mr. Lewis can't help but clash. Each jab, each sarcastic remark reinforcing just how deeply personal and unresolved their co-parenting conflict truly is. At times, it feels like the audience is watching a courtroom sitcom rather than a custody hearing. The humor might lighten the moment, but beneath the surface, it exposes a much deeper issue. Two parents so entangled in personal bitterness that even the names of their own children become punchlines in a public dispute. And while it may earn a few chuckles from those in the gallery, the judge sees it for what it is, a distraction from the real issue at hand, the well-being of the children stuck in the middle of all this name-calling and noise. Throughout the hearing, it becomes painfully clear that neither Ms. Tyler nor Mr. Lewis has legal representation. Both are navigating the courtroom alone, armed mostly with determination, emotion, and a shaky understanding of legal procedure. This lack of formal counsel quickly manifests in a series of missteps, especially when it comes to making objections. Time and again, as each party presents their evidence or testimony, one will abruptly interrupt the other with an objection. But rather than being grounded in recognized legal principles, like hearsay, relevance, or improper evidence, these objections often come across as emotional outbursts or attempts to derail the opposing side's points. For example, when Ms. Tyler offers bank statements as proof of child support payments, Mr. Lewis interjects with frustrated, "That's irrelevant." The judge prompts him to clarify the basis for his objection, but Lewis struggles to articulate a valid legal reason. Instead, his objection sounds more like a personal attack than a procedural challenge. Similarly, when Mr. Lewis attempts to question the authenticity of documents Ms. Tyler presents, she objects loudly, claiming he's just trying to confuse the court or drag this out. These protests, while understandable given the tension in the room, do not meet the court's standard for valid objections. The judge patiently reminds both parties that objections must be based on specific legal grounds to be considered. But the courtroom exchanges devolve into a cycle of shouted objections and equally heated responses, with each side misunderstanding the purpose of these procedural interruptions. At one point, Ms. Tyler objects to a question posed by Lewis, citing emotional harm as a basis, an argument that prompts the judge to explain that objections should focus on legal relevance or evidence rules, not personal feelings. This back and forth reveals the wider challenge self-represented litigants face in the legal system. The difficulty is separating personal grievances from courtroom protocol. Both parents clearly want to protect their interests and their children, but their limited legal knowledge leads to procedural confusion that slows the hearing and frustrates everyone involved. The judge attempts to guide the process gently, explaining when objections are proper and when they are not. But the persistent misuse of objections highlights a deeper issue, that effective courtroom advocacy requires legal training, something neither party currently possesses. In this hearing, the courtroom is not just a stage for legal arguments, but a battleground for emotional and procedural misunderstandings. The misuse of objections, rooted more in passion than law, underscores how challenging it is for laypeople to navigate family court without professional assistance. As the hearing progresses, the courtroom atmosphere grows increasingly tense, with both Ms. Tyler and Mr. Lewis veering off into heated debates about custody, living conditions, and the children's well-being. Sensing the risk of losing control over the scope of the case, Judge Vonda B. steps in decisively to refocus the proceedings. Addressing both parties firmly but fairly, Judge Vonda reminds them that the purpose of today's hearing is narrowly defined. She explains that the court is here to determine the child support obligations and health insurance responsibilities, not to decide custody arrangements or assess where the children are living. The judge stresses that these other issues, while important, belong to separate legal processes and must be handled in the appropriate forum. Her tone carries the weight of experience and authority, cutting through the distractions. She tells Ms. Tyler and Mr. Lewis that bringing up matters like eviction, sleeping arrangements, or even the emotional well-being of the children only muddies the waters and slows the court's ability to reach a clear decision on the financial questions at hand. Judge Vonda's reminder serves as a crucial turning point in the hearing. It acts as a checkpoint, signaling to both parties that they must stick to the agenda. She encourages them to present evidence and arguments strictly related to child support payments and health insurance coverage, which are the legal issues the court has jurisdiction over today. By clarifying this boundary, the judge not only maintains courtroom order, but also helps ensure fairness. She prevents a hearing from becoming a free-for-all of personal grievances, which could otherwise overwhelm the process and jeopardize the children's best interests by delaying resolution. Despite the reminder, occasional attempts to raise extraneous topics persist. Yet, each time, Judge Vonda swiftly redirects the discussion, reinforcing the focus on child support. Her firm guidance helps contain the conflict and steer the hearing toward a productive conclusion. This intervention underscores the judge's role as a gatekeeper of legal procedure, ensuring that emotional and personal disputes do not derail the court's mission to provide clear, enforceable rulings on child support matters.